up, everybody? I'm K. Marie.
I am Lou.
I'm Mary. And we are
Mirth in the Midwest. All right, you guys. We are back for what?
Part 2.
Dose.
And we are picking up right where we left off, so we're going to get right into it. Stick around. Opening statements were made on April 6, 1991, and then the jury began hearing evidence on April 8, 1991. So, in addition to the testimony by Rodney Wood, the jury heard from April Bowman and Stephanie Bell. Those were the two 15-year-old girls that traveled to Kentucky with them.
Okay.
Both testified that they were alone at the Miller residence from approximately 11:30 p.m. till 2 a.m.
So they left them girls there while they went and did their deeds.
And then came back and they left for Kentucky. But that proves there that Miller wasn't there.
Yeah, Perry's ass, he wasn't in the fucking house.
With his whole, the last time I saw them was at midnight.
Oh, yeah.
So the prosecution also presented...
Midnight, remove that damn one.
So the prosecution also presented testimony from Carol Kelly. She was a hardware store clerk, and she testified that she had sold 12-gauge Remington shotgun shells to Miller the day before the murder. So Mr. who's never seen the shotguns was out buying bullets for him. This is what was presented.
What was he going to do with the bullets then if he ain't never seen the damn shotgun?
Lisa Black.
Was he using it for decoration?
Probably. Maybe he wanted to make a necklace.
Oh, okay.
Lisa Black, a hair examiner from the Indiana State Police, testified that one of the pubic hairs recovered from the victim matched Miller's pubic hair.
Leaving all
type of evidence behind.
How did that get there?
It matched his standard. So his type of pubic hair.
Ugh,
Then one of them,
I bet it was like,
did the do inside of her. One left some pubes. Y'all just all burnt up.
They
now.
Nasty.
Dana Peterson, who was a serologist for the Indiana State Police, she testified that she detected an enzyme marker on a swab taken from the victim, which could have matched any of the three suspects, Miller, Harmon, or Wood.
Put all of that.
So
wait a minute.
There's exactly. There's a lot of like, we got this. If it may or may not be them. There was a lot of like, there was no like hard concrete evidence.
If it can match three people, it can match any damn body.
Exactly. Right. So there.
What the fuck does that mean?
Exactly.
I'm sorry, but that damn pube sound like it's his.
So.
Fry them. Oh, we don't fry people here. How do we get rid of?
We used to fry people.
How we get rid of them now? Lethal injection.
Lethal injection, and that's really, really rare in Indiana now. It's like it's far and few between, and I think the cases have to be so severe. No, seriously,
I'm telling you,
I'm pro death too. Like honestly, chomos, motherfuckers who anybody who takes somebody's life, I feel like you should be fried. But when you a chomo, they don't give you life for that shit. They give your ass what? They might give you
25
and then probation
and
in-house
bullshit,
probation.
so you can go back out and molest some more damn kids.
Sex offender.
Nobody gives a fuck.
Fry them. It's a lot of things that I believe that your ass should be fried.
I'm gonna tell you, I believe the French had it right. I think we need to bring back the days of the good old guillotine. Let's just start chopping some heads off. And let's make sure that the blade's not sharp. So maybe it might go and then you don't really die right away. And then we got to reload that bitch up and make sure it's the old antiquated ones where you still got to pull it up for a while so they can suffer. Like, I don't think that they should get a pleasant, smooth, easy, humane death, because nothing about what they did to this woman was humane.
Nothing.
And they deserve the fucking worst. It needs to be as horrible as what you did without somebody else having to get involved in that horrible act. The way that you die, like even if it's just like, I don't know, slitting the vein and letting you just bleed out real slow, or I don't know, starving them. Put them in a hole and let them maybe scavenge for food. Like maybe throw something in there every once in a while. Like it might be something that's nourishing, but it's like rotten, and then it's like, sorry about your luck. Maybe every once in a while, intermittently giving them water so they last a little bit longer, but just letting them starve to death. All of these things sound reasonable to me. I'm with it.
Okay.
I am one who is like, Torture their asses. Torture them. Why not?
Why not?
Why not? They didn't see anything wrong with torturing her. They had no remorse. They had one hiding in goddamn sandboxes and leaves and shit. Fuck them. Yeah, fuck them.
And you heard what she said?
Yep. I said it and I meant it.
So, as we said, they said the swab couldn't match any of the three suspects. However, evidence from Audrey Lynch, she was an FBI DNA expert. She suggested that only Harmon had left any trace of DNA.
Okay. So Harmon was the kid that was staying with them that wasn't...
Nope, Harmon was the stepson.
Harmon's the stepson, and he was the only person who
19-year-old.
left actual physical evidence
Yes.
that they could pin to him.
Yes. So, additionally, the state put on evidence that Miller had previously visited the White Hen Pantry in Valparaiso while working on his delivery route and had made a comment to a coworker about Christel.
What did he say about...
I do not know. He just made a comment.
I thought it was something real fucking inappropriate.
Probably. This was just like the different evidence that was being presented. So Miller actually presented a defense of actual innocence based on alibi,
Of course.
and lack of proof.
Alibi. Listen, the people who were in the damn house said you weren't there, sir. Fuck your bullshit ass alibi. You weren't there.
Miller's wife, Betty, here she come in here.
Okay, Betty.
She testified that she called their home from work at 1:30 in the morning on November 14th and spoke with Miller.
He was probably back by then.
Probably. Since the boys left at 2.
Yeah.
Additionally,
Betty, you told us nothing.
Additionally, Betty's coworker, Raina Murray, testified that she did see Betty on the phone, but she was unable to state with whom Betty was speaking. So then why you talking?
Exactly, ma'am. You don't even know shit.
Additionally, clinical psychologist Frank Brogno testified during the defense case, stating that Miller had no psychological or psychiatric syndromes and no severe or major personality disorders, and specifically that he did not show powerfully aggressive and sadistic patterns of behavior or sadistic patterns in his thinking, his perception, his mood.
But what does that tell? That doesn't mean anything.
That don't have nothing to do with anything.
This is where his defense fucked up.
Okay.
Because they brought in this of, we've had this psychologist look at him and he shows no psychological or psychiatric syndromes and he's not an aggressive or sadistic person. Because they said this, the counsel brought out during his cross-examination of Wood that Miller had actually been in prison and was on parole, currently on parole from a kidnapping and rape case.
I'm done. You know what, justice system? I'm talking to the judges, the prosecutors. Stop letting these fucking disgusting ass people out of jail. Like, if I hear one more case, I mean it. I'm gonna lose my shit.
You gonna lose your shit tonight. I'm sorry.
Stop letting these motherfuckers out. They did it once. There is no I'm sorry. If you are abducting someone and raping someone, what kind of rehabilitation are they doing? Are they fucking kumbayaing you? Are they freaking in there like conversion camp? We know conversion camps didn't work. You can't. People have intentions. They do the shit they're gonna do. He did it once. He'll do it fucking again. What the fuck?
And so, this was all brought out because of the testimony of Etta Thomas and Bev Hunter. Both of them testified that they had been assaulted and raped by Miller. Additionally, Hunter testified that Miller had been tried and convicted for her assault. So closing arguments were made to the jury on April 17th, 1991.
A day before my birthday.
And the jury returned verdicts of guilty on all counts.
Yeah.
The following
Guilty as
day,
hell.
the penalty phase began. The state entered all of the evidence from the guilt phase and rested. Miller presented testimony from social worker David Sexton regarding his clean work record while previously incarcerated.
No one cares. No one cares.
I don't care if you behaved in jail.
You behave because you had
behaved
to.
because you had to.
I ain't got shit else to do. Of course I'm gonna behave.
That whole getting out early for good behavior. Of course I'm gonna be good in here because y'all gonna let me out earlier.
And I don't have shit else to do.
And I don't have nothing else to do. But anyways, additionally, Miller's stepdaughter, Debbie Martinez, testified as to his gentle nature. And Miller's parents, Harry and Mildred Miller, both testified that they did not believe him to be aggressive or sadistic.
I like to call bullshit on the daughter's testimony, too, because if he was directing those boys to do that stuff, he probably assaulted her, too.
At some point.
Bullshit.
He sounds like he assaulted his kids. He sounds like he was just a straight up pedophile and had been doing it and been getting away with it.
Yes. So Miller himself actually took the stand briefly, and he stated that, I'm sorry that all this happened, but
you sorry all this happened?
But, I didn't have anything to do with it. Counsel made very brief closing arguments, and the jury returned a recommendation of death that afternoon.
Yeah.
The court held a sentencing hearing on May 20th, 1991. Miller made a lengthy statement to the court reviewing the evidence and arguing that he had been falsely convicted of the crime to satisfy the public's need for revenge. The court then imposed a sentence of 220 years imprisonment on the non-capital offenses to be served consecutively, and a sentence of death on the capital offense, finding that 4 of the statutory aggravating circumstances existed while no mitigating circumstances existed. So they were saying, like, there's nothing that you provided to us that says you should get less than this.
Because of the things that you did fall under those guises of getting that death penalty.
Right. So, of course, it didn't end here. Miller wasn't going down without a fight.
Because they always got to waste our tax dollars, too. On top of being pieces of shit and killing people, then they got to waste our tax dollars because we ain't got shit else to spend our money on.
Yep. So that's where we get into the post-conviction relief. Yeah, okay. So, boom. Court appointed Mr. Onks in the Porter County Public Defender's Office to represent Miller on appeal. After the trial, court denied a motion to correct errors, which was based solely on the presence of a juror who had heart problems on the morning of the close of the guilt phase.
Then
he had a heart attack while leaving the courthouse that evening and did not return for the
one that can't walk. The one that couldn't walk and had to sit in the wheelchair and get wheeled in.
So Miller,
legs don't work.
Miller appealed directly to the Indiana Supreme Court because he was saying felt like he was wrong because a juror had to be replaced after evidence had already, when we were in the sentencing, the guilt phase. Y'all had to, because the juror had a heart attack, so they had to replace a juror, and so he was saying that was wrong. I was da-da-da-da-da. He first claimed fundamental error occurred when the prosecutor repeatedly stated his opinion as to the truthfulness of the witnesses and the guilt of the defendant.
I can say my opinion all damn day.
The Indiana Supreme Court rejected this argument, finding that the prosecutor had only commented on the evidence. Summarily, the court rejected the error asserted by the prosecutor, calling defendant a mean son of a bitch. So that was also in Miller's appeal. He was like, and they call me a mean son of a bitch.
Oh my God, it hurt my feelings.
My feelings are so hurt.
That's not gonna be all that's hurt. Hope you enjoy jail.
That's gonna be
You're gonna need ice pack.
That is gonna be hurting.
He also said that there was another error committed because they quoted the United States versus Wade case.
And what's wrong with that?
Nothing. They were like, yeah, no, we don't see a problem. But this is exactly what they quoted. They said, law enforcement officers have the obligation to convict the guilty and to make sure they do not convict the innocent. That's my duty. They must be dedicated to make a criminal trial, a procedure of the ascertainment of the true facts surrounding the commission of the crime. To this extent, our so-called adversary system is not adversary at all, nor should it be. That's literally what they said.
Yeah, so he had all these bullshit complaints. His actually, sometimes the guilty have somewhat plausible, little
He
bit.
Does. I'll get to it.
Girl, ain't all these sound like Mickey Mouse.
No, he does.
They pooped on my crayon. I didn't like that crayon, officer.
No,
they called me mean.
So the court rejected all of Miller's challenges to the Indiana capital sentencing scheme. Mm-hmm. He also challenged that there was an error in asserting the knowledge of his prior convictions tainted the pool.
No, but you brought that in.
Right.
You brought that in on yourself. You did that when your defense attorney decided that we're going to talk about there's not a mean bone in his body. And the daughter, my daddy's such a good man. He's so nice. He ain't never done nothing mean ever. He ain't never had a crossword for nobody.
that was also rejected.
Yeah.
They rejected that claim as well.
They're like, that's cute. Keep going.
He then proceeded.
Oh, Judge Bradford, he always be being busy and stuff, girl. Sorry.
So Justice DeBruler wrote a concurring opinion in which he reviewed the appropriateness of the sentence and found that basically we're gonna keep the death sentence. They thought that they saw that it was appropriate.
It's good. It sounded real. It sounded fitting.
He wasn't done. Miller, like, I'm not finna die. Miller then proceeded immediately to the Indiana post-conviction review process, beginning again in Porter County. The Indiana public defender entered its appearance on behalf of Miller by deputies Ann Farr and Joanna Green.
Mm-hmm.
The initial petition for post-conviction review was filed on March 17th, and these were the errors that were listed. He denied effective assistance of counsel on direct appeal.
Okay.
That his conviction and sentence were unreliable because fundamental error occurred both at trial and on appeal.
I would like to say that his ineffectiveness of counsel partly is his own fault because he had an attorney and the attorney was allowed to step down, which makes me believe, because there's only a couple of reasons why an attorney can like back out. You did something and the attorney they aren't obligated to share this because of attorney-client privilege. But if you share something with them that makes them know that you're guilty, they don't have to represent you. But anyway, ineffective counsel. Yeah, he had ineffective counsel. Okay.
He was denied effective assistance of counsel at trial.
Mm-hmm.
The Indiana capital punishment statute was unconstitutional on its face. And as applied to Miller, the imposition of the death penalty on Miller would violate the United States and Indiana Constitution.
No, it don't.
He also says that he did not receive a full and fair review of his conviction and sentence by the Indiana Supreme Court. So what did he expect? In this appeal, he's complaining about stuff that happened during the first one, as well as when he took it to the Supreme Court, and that he's saying they also didn't review it correctly.
Okay, because I was going to say, what does he mean they didn't review it correctly? Because they looked at all of his points. He just didn't like the answer. Doesn't mean they didn't review it appropriately. Exactly. He just didn't like the answer. It's like a kid. Like, you tell them, they say, Ma, I want to do this. And you say no. And they be like, you don't let me do anything. No, I decided that that's not the course of action we're going to take. Sir, it's baseless.
So Miller's counsel, when they took this review, they also moved for a change of venue from Judge Bradford for the post-conviction proceedings.
Don't be hating on Bradford. He be being busy and he do his damn job.
Judge Bradford, he was like, okay, I grant that. Probably because he was tired of dealing with him.
Oh, I know it. Bye. Get somebody else. Let him do it.
So Judge Raymond D. Kickbush was appointed as special judge to hear the post-conviction proceedings.
I've never heard of that one, but okay.
He initially set a date of January 10th for the hearing, but there was a motion from Miller's counsel to have the hearing pushed to April 10th.
Just trying to buy every inch of minutes of time to not die.
In the original trial, y'all motioned for early trial. Why y'all pushing back now?
Because we're trying to keep him from frying. He don't want to go zap bug light.
So Miller, by counsel, filed his amended petition for post-conviction relief on February 14th, 1996. And these
oh my God, look at how long of a time that was from when she actually died.
In 1990.
To this bullshit. Y'all done wasted 6 years
later of court.
Of garbage. Crap. And can you imagine that family? How to sit on pins and needles of every time this fucker comes with, oh, well, we got another appeal. And probably the fear of,
oh, he might get out.
He might get out. He might not have to actually be accountable for his actions. We know he did it. But now, it's a possibility on some technicality, he might get, can you imagine every time it comes and the next thing, and then you don't have, it's like they can't get to the end, and it's like it's never going to be an end.
No.
You're never going to
But we can't even begin to get closure.
Because we keep having to deal with your dumb ass.
Right. So, please bear with me. First, these were the specific errors. The appellate counsel provided ineffective assistance by failing to present several errors to the Indiana Supreme Court. Namely, the trial court's refusal to hold the trial outside Porter County.
But they got the jury from outside.
They said the trial court's selection of a jury from Pulaski County, which counsel alleged was tainted by the publicity of this case. The trial
Where'd
court,
they want to get the damn people from? Mars?
The trial court's failure to appoint co-counsel until the first day of trial. This is where I'll say he had a point. Because when the first lawyer left, they did not appoint the public defender angst until the day before his trial.
Now that's different. And why was that?
Something going on with angst, which we get into that later.
Okay.
He had some stuff going on. But yeah.
Okay.
So that's where I was like, okay, he had a legit reason there. The inclusion of an alternate juror during the penalty phase deliberations.
To me, that seems ridiculous because you were already found guilty.
But he's saying that the counsel didn't raise a motion to correct the errors during that time.
But the thing is that what, in my opinion, is that really an error? You were already figured to be guilty.
But then he's saying that you had somebody else come in out of nowhere in the penalty phase.
It's not out of nowhere. When you have jury members and you're a stand-in or whatever they call it, like like it's a possibility, you still have to listen to the whole trial. It's not like they off at work hanging out and then all of a sudden they call him back and be like, oh, come on now, we done found him guilty. What should we do to him?
He just felt like a change in juror this late in the game was an error.
They heard all the facts.
He felt like his counsel should have spoke up for him then.
Oh, wham.
So then, the other one was that he was deprived of a fair trial. Also, that they did a direct appeal, provided ineffective assistance of counsel, failing to preserve issues from trial in the motion. Basically, he was complaining about he felt like his counsel didn't object enough. Like they were letting stuff go by
that should have been like challenged.
Yeah.
Okay.
Failure to review discovery materials provided by the state. Failing to challenge the destruction of potentially
that's not true.
Exculpatory evidence. Failing to request experts to test the DNA, serology, and hair evidence because all of the agents that did were provided from the state.
But as far as the looking at the evidence, I don't think that that's right either because his attorney petitioned for more time because he needed to look at the evidence.
Yeah. Failing to properly prepare jury selection, whatever. Failing to pursue his pretrial motion to exclude evidence. But the reason why they didn't do that is because they gave the attorney more time to review. Failing to depose a number of state witnesses. Failing to object to inappropriate questions by the state during its direct examination. Failing to adequately cross-examine the state's witnesses. Failing to object to...
He makes me tired. I feel like I need a nap now because no one's listening to you anymore, Miller. No one cares.
Failing to object to leading questions, the omission of the autopsy report, and the copy.
Wait a minute. He don't want none of. Wait a minute, y'all. First, he's talking about the evidence,
I want the evidence out. I want the autopsy report
gone.
Y'all can't talk about my past. Out.
Did anybody even die? What are we talking about in this case? He don't want the victim mentioned. He don't want none of the sites mentioned. It ain't nothing for nobody to know. Take all that shit out. And then just listen to my daughter and my confused ass wife.
Yeah.
Listen to my daughter that I've probably molested or done
and the
something
person
to.
that came and said that he had good behavior while being incarcerated.
Oh yeah. Listen to but no, don't talk about my previous conviction.
Don't talk about why I was incarcerated. Just say I was good while I was in
while I was incarcerated, I was good, y'all.
And K Marie is back.
Hello.
Hello, hi.
Hi. Oh shit. Oh my god, I almost fell.
Please don't.
Please don't. We don't have time for that.
So, failure to file proper motions. Oh, sorry. So throw the autopsy report out. The competence of 9-year-old Josh Montmayor. He was the one who actually found Christel's checkbook in Miller's driveway.
Mm-hmm. Oh, what he say? He planned the 9-year-old planned it. Yeah. The 9-year-old did it.
Yeah.
How confident do you have to be to say, "Ooh, look, what is that?
A checkbook." You sound confident to me.
Failing to file proper motions regarding Miller's prior conviction and prior bad acts. Failing to, I love how like rape and kidnapping is just called a bad act. Failing to make an opening statement during the penalty phase. Failing to object to the several indictments of prosecutorial misconduct, and was generally ineffective because he had not tried a capital case in post-Furman era. Had not tried a criminal case in the 5 years prior to his representation of Miller, and had not attended any criminal defense seminars until the time of trial. So basically his complaint was that his public defender was inexperienced and unprepared.
What I want to tell you, this is what I want to say. Mr. Miller, is he still alive?
Yes.
He's still haunting this earth? Okay. So, Miller, maybe you're in your jail cell right now getting belt raped. But I would just like you to know that you really want to discuss everyone else's failures, the failures of the courts, the failures of the justice system, the failures of the jury. I mean, even the failure of the poor man's heart that fell out. You want to discuss the failures of everything, but what you are failing to discuss is your failures. And I mean, the list could go on like this laundry list, but so much further. I mean, you failed to even keep your story straight. You're out here buying ammo for a gun that you don't know exists. You are hiding when you know that the cops are coming in a sandbox with sand, a parka, and leaves, like you are on a black ops operation. You are failing to realize that if you just go ahead and be part of this criminal life, you got a car, you a grown ass man, drive to Mexico, sir. I don't fucking know. You failed at these children that I believe that you assaulted. I'm glad that you are in jail forever and hopefully will die. A horrible, maybe like the injection will go bad. But you know, like burn them up a little bit so you can like scream for a while. All I know is that I can't even take these seriously. These are failure. I mean, there's a couple. There's a couple.
That were like, okay.
But like, throw out the autopsy?
Yeah, he wanted to throw out the autopsy.
Get that out of here. Facts. Who wants to talk about facts? Well, dude, your whole life is a failure. You are a failure. You suck.
The hearing on the petition for post-conviction relief, it began April 10th, 1996. And so attorney Ronald Ongst was the first witness. He testified that he was appointed in November 1990 at a special rate of $75 per hour. And that he, could y'all imagine, in 1990, $75 an hour?
Listen, you want my professional expertise, then you gonna pay.
So, make it $100. And that he stated that he had attended a death penalty seminar in February 1991, shortly before Miller's trial. No co-counsel was specifically appointed, but Robert Kentner volunteered to assist Ongst and did assist with research and investigation prior to trial.
Okay.
Ongst testified that he filed a motion for speedy trial because he felt the state would not be able to get their evidence together, but that when the judge granted the prosecution's motion for continuance, he did not renew the motion for speedy trial because he felt that the trial was set within a reasonable period of time.
Okay.
He stated that after reviewing his time records that he had not received much of the state's evidence until April 10th, 1991, which was after jury selection. Ongst testified that he did not remember deposing several state's witnesses, and his time records did not reflect any depositions of those witnesses. Ongst did depose Dr. Bromno during the first week of trial prior to putting him on the stand during the guilt phase.
Okay.
Ongst was questioned about his efforts to investigate the check that Carol Kelly testified at trial, stating that Miller had bought bullets. But so what it was a check that was used. He said that Ongst didn't actually look into the check. He stated that he had obtained Miller's checking records, but had not obtained those of the hardware store. And so Miller's counsel then entered into evidence the bank records of the hardware store and an affidavit from Sherry Miller, which showed that the Miller check that was discussed at trial was actually a check from Cherie Miller's account, not Perry Miller.
But
and
they're
that Cherie,
married.
no, Betty is his wife. Cherie was not related to Perry. Mm-hmm. So basically what happened is they looked at this check, saw the name Miller, and they were like, well, yeah, we got Miller buying bullets for a shotgun.
But do you know
and so he's complaining that his counsel didn't further look into that.
Right, because the first thing that should have came up was how common the last name Miller is.
Wait a minute, so he didn't buy bullets? Who was Cherie?
Not related.
Nothing to do with that. That's a very common last name.
Wait a minute now, hold on.
Your last name is common.
Hold on.
You say for instance, you go back. No, listen. Say for instance, she bought some bullets and they questioning her about a case that she don't even fucking know about. I would be mad as hell.
Hold on. Because that's a big part of the evidence.
That's a big part of the evidence. That's what I said. There are things.
That's a big thing.
Yes. So why are you questioning somebody that's completely unrelated?
What they should have, what the prosecution should have done is they should have looked to see if there was any link between the person who had that check and Miller.
There wasn't. They said that there was no.
They didn't look hard. No.
So here it is. The prosecution spoke to the Carol Kelly who worked at the hardware store. Because I guess they just kind of they were checking with all stores to see if there was any purchase from a Perry Miller for shotgun bullets, or they probably were looking for Harmon Wood or if any, well, not Wood because he was only 16, or Harmon because he was 19. I don't think you could buy bullets at that time at 19.
You can, 18.
Mm-hmm. 18? Okay. So
isn't it interesting that you can actually buy something that you'll kill somebody with, but you can't have a drink? Talk about that.
Yeah.
So I think what happened is they were just kind of checking all hardware stores, and they get to this hardware store, and Miss Carol Kelly, she's like, oh, well, yeah, I do have a check from a Miller that was used to pay for some shotgun bullets the day before the murder. And so they took that and ran with it. And his counsel didn't do any further follow-up on it.
Yeah, that's looking, okay, honest, I was on your side. Now I'm looking like, dude, what you doing?
So on cross-examination by the state, Onk stated that he did not hire serology, hair, or DNA experts because he did not believe the evidence from those items to be damning to his client.
Well, they weren't.
They weren't.
So why would I spend money on that shit?
It was a pubic hair that matched the type of pubic hair that he has. There was a DNA sample.
How about what?
What if somebody's looking at somebody's curl pattern? Can you drop your drawers real quick? I'm just trying to see
color.
Your pubes only have 3 curls in it. It's not yours.
And so
this is a wavy curl.
That was the evidence. The other evidence was, there's a sample that could match any of them.
Come on now. What? And if it match any of them, it match anybody, so it ain't none of them. What you talking about?
And then it was followed up with a sample where the only DNA evidence that they could actually say was concrete was Harmon.
Yeah.
So, okay, so
what are we talking about here?
So Onks is I don't feel there was no need for me to test this stuff because they didn't have nothing. He also stated that he did not believe it was a calculated risk to have Dr. Brongno testify to Miller's lack of sadistic behavior, and that Miller had concurred in the decision to have Brongno testify.
Oh, now wait a minute.
So that was the other thing. So,
Miller, you said it was cool. Now all of a sudden, since they was bringing in them old cases, you're like, oh shit, wait a minute.
Yes. So then the state also questioned Onks about his legal experience, and he came with it. He said, hey, I've practiced law for 23 years.
You tell him.
At the time of the Miller trial, had participated in hundreds of jury trials, between 15 to 20 murder trials, and 3 capital cases. On redirect, Miller's PCR counsel brought out
Look me up on Google is what he said.
Right?
Google me, bitch.
Miller's counsel in this review brought out that Onk's capital murder experience had been in the early 1970s. And that Onks had been disbarred for almost 6 years prior to Miller's trial.
This dude is literally okay. First of all, because I'm Miller. Again, I'm talking to you. You want to complain because he was disbarred and da 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 da. sir, you're out here kidnapping and raping people.
And
I think him being
for like a financial thing or
right. I think being disbarred is a little less criminal than what you're doing.
Well,
and they gave him his license back, so it wasn't too damn bad.
Right. So Robert Kentner was the person that volunteered to assist. He testified that he had attempted to have the pubic hair tested, but as they had not received the hair test results until the first day of trial, he was unable to find a lab to get the test done in a timely manner. John Martin testified regarding his work as appellate counsel for Miller. Martin had not previously worked on a capital appeal, although he did attend a death penalty seminar in February 1991. So this is at this point Miller's complaining about his counsel on the first trial as well as on his appeal to the Supreme Court. At the hearing, several witnesses testified about evidence that should have been addressed at trial.
I also would like to say, you're pulling from a pool of attorneys who are in this Northwest Indiana area. I mean, we do have murders. But you're talking about Valpo. Like, how many murders do you really have that are of the capital? What, you want to go to Chirac? What, you want to go to Chicago?
Man. So then, Richard Bisbing, who was an independent hair examiner, was called. He testified that his examination of the pubic hair found on Christel's thigh was one of Christel's hairs and did not match Miller's known public hair.
Now, wait a minute. I would like to say, we can also test the hair to see if it's male DNA or if it's female DNA.
He did. Apparently, the first one didn't. He did.
How ridiculous is that?
That's what I said. There was a lot of stuff that happened in this case that was like, okay, I see why Miller
this is what
appeal.
This was their test. Hold on.
And
this was the
and at this
right
point,
here. Hold on.
He's still saying he's innocent.
This is what they did. This is what their test was. That looks like a match. Yep.
Yep. It's hair.
It's hair.
It's hair.
It's not fur. It's hair.
It's hair.
Yep. It could be his. I think it is.
Thomas Feeder, who was a independent serologist, testified that the state police serologist testimony that Miller was part of a 3% of the population from whom a certain genetic marker would be found was misleading because the state serologist failed to take into account the victim's blood and the mixture in which the marker was found. So that sample that they took and they said, oh, it can match any of them. The victim's blood was included in that sample. And so he was saying, for you to say that, oh, he was included in the 3%, this, that, and that, or whatever, this was a tainted sample.
So why would they take a sample that had her blood mixed in anyway?
I don't know, but it was.
Is that all they had
going on? It was some tomfoolery. So
that's weird.
Pam Porter, a certified social worker and mitigation specialist, testified that she had found a significant amount of mitigating information about Miller that had not been produced at trial, including information about the death of a sibling. This is all that mitigating information that kind of goes into the sentencing. Like, is there anything that would say that there may have been something that led you to do this? Whatever. So, death of a sibling, a possible molestation when he was in grade school, and possible abuse by a grandfather.
Listen, I'ma just say, I already said he sounded like real pedophilia. It was going on. Because the way in which those children, even the 19-year-olds, said that they were instructed, that is learned behavior. And I wouldn't doubt if his grandfather abused him. I wouldn't doubt it.
Yeah. So then Jack Duckworth, former superintendent of the Indiana State Prison and an individual with whom this court was very familiar, testified that Miller had been a trustee during his first incarceration. He was assigned to a minimum security building outside the wall of the facility.
Good for him.
He also testified that Miller had adjusted well to prison life and had been very dependable in his
He
prison
adjusted
duties.
to putting a little lube on it.
So after listening to all these testimonies, can you guess what happened?
He was denied.
It was denied again.
Sorry, Miller.
And
stay
of course,
in there.
But wait, of course, Miller appealed the denial of his petition. And it was rejected again.
He said, I am not finished.
So at this point, he still had
one more thing. One more.
However, Miller was not done.
Of course he wasn't.
He then filed a case with the 7th Circuit Court of Appeals, and on June 29, 2001,
Baby, bye.
they reversed the judgment of the district court
Wait,
and
what?
directed that the state of Indiana release or retry him within 120 days.
Stop it. Are you serious?
The panel determined that Miller's public defender at his county trial 10 years ago was ineffective.
Stop. Mary. You better.
They gave them 120. They said you either retry him or you release him. So, on August 8th, 2001, after a decade of declaring his innocence, Perry Stephen Miller admitted on Tuesday that he is guilty of the 1990 murder of Chesterton High School graduate Christel Helmchen. So it was August 7th, the day before. Miller entered a guilty plea to the charges to get a plea agreement calling for a 138.
Why are we giving a plea agreement to this piece of shit?
I will tell you why. Calling for a 138-year sentence and was sentenced by Porter County Superior Court Judge Bradford to consecutive terms of 60 years for murder, 50 years for conspiracy to murder, 20 years confinement, 8 years robbery. Miller, now 53 at this time, will instead serve a 138-year sentence for murder.
Never seen the light of day.
He will not be considered for release from prison until he is 112 years old.
You know what bugs me?
No, wait. No, hold it. Because wait. So for Robert and Judy Helmchen, the parents of Christel, the plea agreement finally gave them some closure to the murder, rape, and torture of their then 19-year-old daughter, who had been working alone at night at a right-hand dungeon just weeks before she was to begin college, and she was abducted by Miller and
Lord have mercy.
But the fact, this is her parents, the fact that Miller won't be executed for his crimes also symbolizes to them the unfairness of the justice system. That, quote, "We feel the U.S. justice system is very unfair," said Robert Helmchen. "It's not just because he took Christel's life brutally and joyfully and pre-planned it in great detail, and he gets away with it." Porter County Prosecuting Attorney James Douglas did say that though the chances were very good that they would have won the retrial, that Miller would probably have been sentenced once again to death. Anytime you retry a case after a long period of time, there are problems. These include not only the general ones of fading memories on the part of witnesses and their testimonies, or perhaps even jurors changing attitudes to the death penalty itself, because now it's been 10 years.
They could put me on the jury. We could
also,
fry them.
Also, the specific problem presented in this case by the need to secure the testimony of Miller's accomplices in the murder. 10 years ago, he said the state had some degree of leverage over those accomplices, because the reason why Harmon and Wood gave these testimonies and stuff is because they were offered plea deals. And so it's like, now you ain't got nothing holding over their head, so they really ain't got to testify.
But, okay, actually they do, because did you know that just because you make a plea deal with a prosecutor, it doesn't mean they have to stick to it.
Well,
they can come back years later and say, fuck that plea deal.
But this is what they were arguing, is that, I guess like at this time they were saying, when y'all took those testimonies, y'all had something dangling over their head. And so
I still got it dangling. I could say, fuck this plea deal and your ass going to jail.
So then, on top of that, leverage. So he also said, so it was all of these things, even for a second.
So wait a minute, they didn't serve no time? They didn't serve time? Harmon.
I'll tell you.
Oh my God.
Douglas remarked, even a second conviction followed by a second death sentence would have led to the same round of appeals and the same cycle of delays. So that was his whole point.
It's like it just would have wasted.
We probably could have gotten him sentenced to death penalty again, but Miller would have just pulled the same crap of appeal after appeal after appeal. And they didn't want to risk him getting off.
Right, because every appeal is a chance that he could possibly get away with it.
So from the very beginning, he was the principal player, Douglas said of Miller. Before him, this would not have happened. And so he always felt Miller to be the most culpable. So Robert Helmchen said the 7th Court panel didn't look at the truth and was ready to allow a murderer to walk free. They just looked at the nitty-gritty details of what went wrong with the trial, he said, adding that this is totally unbelievable.
It is unbelievable.
So the 7th Circuit's decision has led Helmchen to believe that the justice system is biased towards the criminal. The victim doesn't have half as many rights as the criminal, he said. This is all what her dad is saying. On the other hand, Robert Helmchen said he and his family are relieved that the long-standing case is over. Mm-hmm. Now, hopefully, we can close the book and try to heal the wounds that the 7th Circuit tore right open again.
What I really wonder, though, is what that court was thinking. Like, I understand what they said, but when you weigh those types of things that were missteps that were made, because nothing is perfect. Even in a lock, stock, barrel case, there's things that are flawed, right? Mm-hmm. So you didn't have the bullets necessarily, but you had all this time that he was missing. Where was he? Because he doesn't have a real alibi. He has an alibi at 1:30. We know that the murder took place before then. Mm-hmm. You also have those boys would not have known about robbing that white hen without him. He delivered to it. He knew the girl. He had seen her and talked about her. Yeah. So they wouldn't have even been like directed to that. Like, these were all things he put in motion. So how do you outweigh, like, how do you take this bit of evidence that you see that there was a mistake made, and then you say, because this little mistake, that outweighs all the other shit that makes him very guilty. Very guilty. And it's not like he's done it once before. He's done it twice that we know about. I don't understand that appellate court. I don't get it.
Well, her dad also said, he said, we will never forget Christel. Mm-hmm. The whole family was killed as a family when she was taken away. Yeah. He added that it had been of great comfort to the family to read comments and newspaper stories by people who agree that an injustice has been done, mm-hmm. and that Miller should have never been given the opportunity to walk free. No. The plea agreement was presented Tuesday to Porter County Superior Court Judge Bradford, who presided over Miller's original trial in 1991 and sentenced him to die. Mm-hmm. Bradford, using the pre-sentence report filed in 1991, accepted Miller's confession and sentenced him to the
138 years.
Yes. Miller will have to serve at least one half of that sentence before he will be eligible for release.
Now, why did they give him an eligible for freaking parole?
Douglas said in his statement that he conferred with the Helmchens prior to entering the plea agreement and that they requested that the court accepted it. So, you asked what happened with Rodney Wood and Harmon. So mm-hmm. Rodney Wood, he confessed to participating in the assault and testified against Miller as part of a plea bargain agreement that resulted in a 60-year prison sentence. Mm-hmm. Good behavior and participation in various prison programs allow inmates to significantly reduce the amount of time actually served, as we've already talked about.
What? So they crochet and now we're going to let him out early? Oh, he can plant a garden. You know what? He's such a good citizen. But no, he's a felon.
Wood, he went to prison at the age of 16.
I don't care.
So at this time, he was 42. He was released February 9th, 2018. So they thought maybe...
They let him out at 42?
Mm-hmm. They thought maybe he was rehabilitated while in prison.
He was not.
Psych! Because just over a year later, Wood was back in custody after being accused of the attempted rape of a woman in LaPorte County. According to the affidavit in April 2019 case, Wood was showing his brother's home to a woman who had expressed interest in renting it. While she looked around, Wood reportedly pulled out a pornographic magazine and instructed her to look at it with him. Mm-hmm. After she declined, he allegedly cornered her in the laundry room and propositioned her for sex. She declined once again, and they moved to the garage where she sorted through belongings and storage bins. I would have been out.
Why was she still in there?
Rodney made a comment to her about the items not being free, and then, grabbing her by her ponytail, forcefully and painfully yanked her head around and towards him, bringing her face to within inches of his exposed and semi-erect penis. The woman ran from the property and flagged down a passing motorist who took her to a gas station to borrow a phone charger so she could call a friend for a ride back to her vehicle. Police report that the stranger who she flagged down said that the woman was crying, shaking, distraught, and fearful.
Of course she was.
The woman's boyfriend reported that she had been deeply disturbed and continues to suffer ongoing negative effects from the incident. Wood was charged in LaPorte Superior County 1 with attempted rape as a level 3 felony and sexual battery as a level 6 felony. But after the victim stopped responding to prosecutors' attempts at contact in June, the state offered Wood a plea agreement. Served 2.5 years.
What?
She stopped. They no longer had a case.
No. First of all, you do not need the complainant to have a case. Once you have evidence of a situation, you do not...
They didn't. They did not have her actual test. Like, they never actually got her testimony. They had what her boyfriend had said, how she had been acting, and what the stranger said she was acting.
She never gave testimony?
She stopped responding.
Oh, my God.
And so they offered him a plea agreement, served 2.5 years in the LaPorte County Jail, the maximum sentence for the sexual battery charge. Wood accepted the plea bargain, but Judge Michael Bergerson rejected it during a sentencing hearing Thursday. He took issue with the fact that this case was filed in the county's high felony court and having been pleaded to the lowest felony level when a level 3 charge carries a potential sentence of 3 to 16 years in prison. So he said the case was filed as a level 3 felony. The court issued bond on a level 3 felony. This man has been sitting in jail for over a year. I realize some of the period of time is a result of some of the continuance that he has requested, but unless I hear something else that would tell me that the state is going to pursue this case and try this case as a level 3 felony, the court is not accepting the defendant's plea of guilty. So what the prosecutor did is that they moved that the attempted rape charge be dismissed and the remaining sexual battery charge be transferred to LaPorte Superior Court 4. Ferguson approved the motion, noting he is bound by the state's decision when it requested a charge be dismissed. Wood's guilty plea to the level 6 felony was accepted in Superior Court for the following day, and he was released on time served.
What?
The prosecutor said in a telephone interview Tuesday that while it was not the outcome the state wanted,
get the fuck out of
here. They were
here.
severely limited after the victim stopped cooperating. So victim blaming.
Because that's always what it is.
What she does view as a win is that Wood will now have to register as a sex offender for the next 10 years as a term of his plea. Because
motherfucking do.
Because when he was convicted in the 1990 case, there was no such registry that existed. So she's like, well, at least he has to register.
Fucking, again, I say, whoop-de-doo.
According to online court database, Odyssey, Wood's current address is listed as 103 Highland Drive, Walkerton. You're welcome.
Please watch your children, your girls, your young teens, your young adults around this motherfucker.
Then we get to William Harmon.
And you know, in Indiana, just a fun fact. This is an open carry state. You can carry whatever you can conceal and carry. You don't have to have a license. You don't have to have a permit. If you live around them, you might want it. Fuck that shit.
So William Harmon, the 19-year-old, September 1992, he admits to killing Christel. A judge decided November 2nd whether to accept William Harmon's guilty plea for the 1990 murder.
Can you imagine living in a neighborhood and he's just like right there?
I wouldn't live in that neighborhood. Harmon, 21, appeared in court Monday to change his plea to guilty on 6 felony charges in connection with the murder of Christel Helmchen, the 19-year-old convenience store clerk who was abducted from the Valparaiso White Hen Pantry store November 14, 1990. Taken to the site, raped, tortured, and shot. Harmon was scheduled to go November 3rd, ruling on killer's plea bargain on trial October 13th. The lawyers agreed to a deal that Friday that would send him to prison for 280 years in return for a death penalty request being dropped.
Yeah.
With his father and sister in the courtroom, Harmon lowered his head as Judge Bradford asked him how he pleaded on each of the counts. Harmon indicated he understood and responded guilty to counts of murder, criminal confinement, rape, criminal defiant conduct? Don't know. Robbery and deviant. Robbery and conspiracy to commit murder. So yeah,
he ended up with the most, honestly, out of everybody. But his was with him, they had the strongest case because his DNA was found in her, right?
Harmon, yes.
He's the 19-year-old.
Mm-hmm.
I mean, I understand that, but I still just feel like Perry was the adult in the situation. Mm-hmm. He was the instigator of the situation. And these kids didn't want shit but $10 so they could go on a fucking road trip. Perry, your bitch ass could have gave him $10.
And the only reason why he got less years is because he played the system.
Because he already had been through it twice.
Exactly. So
he probably, while he was in jail, he was taking all kind of damn notes. All them dang on pedophiles that he was hanging out with probably was like, yeah, if you do this and then you do that, then this happens. And if you do that, because like people think that, well, I don't think many people think that you go to jail and get rehabilitated, but some naive people believe that. But generally what happens is people learn ways to be more sneaky, especially if they're a real criminal. Like, you may have somebody who made a mistake and they get in jail and it scares them straight. Like, I don't want to go down this path. And then they correct, but they're not a criminal really at heart. They were stuck doing some dumb shit.
Yeah.
But real criminals, it's like they're going to school. That's their college.
Yeah.
Prison.
All right, y'all. So that wraps up the case of Christel and the awful Perry Miller, Rodney Wood,
and Harmon.
Cool in the gang. Damn.
They ain't cool in the gang. They is the worst gang ever.
And all of the awful things they did. And I honestly, Perry the worst. Because
he really
not only
is.
did you do all these awful things to her, you then put the family through further torture with all of your crap with these appeals and I'm innocent. And then as soon as you
the
get
manipulation
what you want,
of teams.
Yeah. Then you get what you want and you're like, well, I did actually do that.
Yep, I did it. You right.
10 years later. So, yeah. This one is all...
Isn't it amazing how killers are so afraid of death, but they have no problem with taking anybody else's life?
That part.
Interesting. Somebody should do a study on it.
I'm sure. I bet you there might be one out there somewhere.
I'm going to look it up.
You should.
I'm about to go down a rabbit hole, y'all.
All right, y'all. Well, that wraps it up. Please go follow us. First, click the like and the subscribe button on YouTube. Go follow us on TikTok, Instagram, Facebook.
We about to have a Twitter.
Tweet.
Spotify, Apple Podcasts. We are
Amazon Music. Follow
all
us.
Listening platforms. So please
iHeartRadio.
Leave us a comment. You can also reach out to our email, which is murkedinthemidwest@gmail.com. If you have a case that you would like us to cover, any constructive criticism that you may have, feedback, even if you want to tell us, just say, hey, please reach out. We want to hear from you all. We love that you guys are on this journey with us as we step into video.
Yes, it's exciting.
So we know it's not going to be perfect at first start, just like with our sound when we were just doing audio.
Hold on, y'all. Let's give it a one time for the mics.
All the mics.
I don't know if y'all noticed. I'm sure when you're listening, you're gonna hear a difference.
Yes.
Smoother sound.
You should definitely hear it.
It sounds velvety. It gives the reason to do a little ASMR.
I know. I was gonna.
Oh my God! Don't do it. We're sorry.
We're so sorry. All right, y'all. But we will see you guys next week. Bye.
Bye.